The following is a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys. The Siniard Law Show, answering your legal questions, featuring attorneys Tommy Siniard, Bart Siniard, and your host, Aaron Dacey. This is the Siniard Law Show.
Hello and welcome to the Siniard Law Show, where we invite your legal questions and educate you on various areas of the law. You can call or email anytime. We'll tell you how. Siniard Law has again received recognition as a Tier 1 personal injury litigation firm by Best Lawyers in America. Siniard Law is a father-son personal injury firm right here in the Tennessee Valley. They are focused on giving back to the community through legal education. Tonight we are discussing workers' comp. Tommy and Bart Siniard will give you all the details, so if you're hurt on the job, you will know what to expect. Father and son, Tommy and Bart Siniard, are here to discuss this topic and answer your questions. Good evening, gentlemen.
Good evening. First of all, Aaron, if you're injured on the job and your employer employs 5 or more people, okay, regardless of how the incident or accident happened, you're entitled to workers' compensation benefits. And those are, under Alabama law, 100% of the medical, both now and in the future, for the injury you suffered on the job. And the future is forever. No deductibles, no copays. The employer or the employer's workers' comp insurance carrier has to pay all of it, now and forever. The second thing you're entitled to is what's called temporary total disability benefits. And that is 2/3 of your average weekly wage as long as you are out on doctor's orders. And 2/3, that includes your fringe benefits on some occasions, and so we have to value that in. But that must be paid each and every week, and that money's not taxable, state, federal, or local, until a doctor releases you from his or her care. The third element is if you've suffered a permanent injury, permanent partial disability or permanent total disability, impairment rates are assigned by the doctors who treat you, and that gives a guidance as to what the value of your permanent partial injury is, or permanent total. And we could go on and on as to how much money that is in the formula, but it is a formula.
Yeah, it's like literally an arm is worth this much,
yes,
right? The leg.
Yes. Yeah. Now we can increase those values through some legal experience, but that's too long for this show. But yeah, it's pretty gory how they calculate the value of a hand, a finger, an arm, a leg, an eye. But we can enhance that with some legal skill. If you're killed on the job, the person entitled to recover are your beneficiaries, and that means your wife or your minor child. And again, it's fixed that if you have 2 dependents, they're entitled to 500 weeks at 2/3 of your pay. It doesn't matter how big a wage earner you are. You could be a neurosurgeon or you could be a plumber. You're going to get 500 weeks at 2/3 of the pay for death. And if you are injured by a third party, that means someone that is not a co-employee, you really have 2 cases. Like a Pepsi truck runs a red light and hits you while you're running an errand for your job. You have a workers' comp case. Why? Because you were on the job. The second case is because the Pepsi truck is at fault, ran the red light. We handle those third party cases. Finally, if you are discharged for making a workers' comp case, that's called retaliatory discharge. We do those. And if you are injured because a machine was not properly guarded, that is a separate case. If the machine was bypassed, not guarded in the first place, or you put the guard on and it was inadequate, then that's another claim arising out of the workplace.
All right. So if you have a question on this topic or any legal topic, just email us questions@siniardlaw.com or call us at 844-7000-LAW and your question may be featured. Now to our legal tip of the week. What exactly does workers' comp cover? We've kind of touched on that a little bit. When should we report an on-the-job injury to our employer, and what are some common mistakes to avoid?
Yeah, so there are time limits to this. You can't just, go weeks and weeks and weeks and then finally decide, oh yeah, by the way, I hurt myself, back in March. That's going to be a problem. In the statute, there's a 5-day notification period. And so you don't have to report it immediately, but you really need to do it soon. If you have waited too long, there are some ways around that are kind of too complicated to go into here, but you need to report it to a supervisor, somebody higher up the food chain at your job, and preferably do it in writing. Typically what happens is most employers know to fill out what's called a first report of injury. That's a form that's distributed by the Department of Labor. Now it's the Alabama Department of Workforce, I just learned. But, it fills in the basics. It's a one-page thing, where you were, what time you got hurt, what body parts hurt, a description of the incident. That's supposed to be done relatively quick. And then you go into being under workers' comp. The frustrating thing about workers' comp is you don't get to choose your doctors. And we handle a lot of workers' compensation cases for clients. And I'll say that is sometimes the most frustrating part. And it's not that they don't like their doctors, but that they feel like they don't have the right to choose. And then it's also this: workers' comp has the right to approve the medical treatment recommended by your doctor. So we run into issues a lot of times where your doctor, who's approved by workers' comp, says, well, you need a lower back surgery. You have a herniated disc in your L4, L5, and we need to get that out and fuse the vertebrae. Well, sometimes workers' comp will review it. It's called a utilization review. They'll review it by some independent doctor who says, no, that's really not needed. You don't need that surgery. And then you get in a whole battle over what treatment you get. So that can be a headache, and it usually is a headache. Not because your doctors are bad, just because workers' comp insurance is kind of the puppeteer, so to speak, and says, okay, yeah, we approve that, or no, we don't approve that. So, just know that going into it it's not always a walk in the park getting the medical treatment you need.
So it might be a good idea to call these guys first. Let's get to our viewer question. This first question tonight is an email from Amanda. She says, I'm a sales rep and I was visiting one of our customers' warehouses as part of my job. While I was there, I was wearing heels and ended up tripping and falling, which caused an injury. I'm trying to figure out how this situation would be handled. Would this be covered under workers' compensation, even though it happened at a customer's location instead of my main workplace? Also, does the fact that I was wearing heels make a difference? And in a situation like this, who would be responsible? The company I work for, the customer where it happened, or neither? Any guidance would really help. Thanks, Amanda.
It could be both are responsible. Understand this: under workers' comp, you don't have to prove fault. And in fact, if the injury occurred from your own fault, workers' comp applies, unlike a car wreck, for instance, situation. So if you're injured, even at another person's premises, workers' comp would cover it. Now, it's another question as to whether the people that own the location you were in are liable. Just because you had a fall doesn't mean they're responsible. And the law in regard to injuries from slip and falls or trip and falls is that the premises owner had to be aware of the defect and failed to remedy it. So let's take a grocery store setting. A person slips for reasons unknown. And you say, well, you were on the premises of Target and you fell, therefore Target's liable. Not so fast. You'd have to prove that there was a hazard, which if there's no substance on the floor, the burden's on the injured party to prove there was a slippery substance and it was there for a length of time that Target knew or should have known that a hazard existed and they failed to remedy it or warn against it. So there's not enough information in the question here from this viewer as to whether or not there was a defect in the premises that the premises owner knew or should have known. So we can't answer that. Maybe. Now, are high heels a defense? No. You know, there's half of the population wears some heels from time to time, and we just don't rule out claims against women because they wear different shoes than men.
Well, that's good to know.
Yeah. You know, high heels, though, I will say, going off on a tangent here, the insurance companies do try to give us problems with that. They will try to argue that whatever shoes you're wearing somehow contributed to the incident. So if you trip on something or you slip on, you know, we've had people slip in, you know, flip-flops, they'll try to bring that up. Trip in high heels, they'll try to bring that up.
Or shoes with plastic bottoms.
And so, you know, be careful when you're interacting with an insurance company. Just know they're always looking for some rock to hide under. And while what shoes you're wearing shouldn't matter, I'll tell you, in reality, sometimes it does.
That's really interesting.
Yeah.
So this lady, she had her job that she was on the job and then was at another location. So who would be covering that? Her insurance at her work or the client she was visiting?
It kind of works in tandem. Like if there's a claim to be made against the warehouse she was at, she's definitely got workers' comp. If you trip and fall while you're on the job, even if it's, you know, you're not at your workplace, it's still covered by workers' comp. Even if the trip and fall was your own fault, you can trip over your own shoelaces as long as whatever you were doing was within the scope of your job. We handle cases like that all the time. Somebody slipped going up the stairs delivering a package that's covered by workers' comp. So it can be your own fault. Like my dad was saying, it's not a fault-based system. And the reason for that is, it's a long history lesson, but the trade-off is you don't have to prove fault, but you can't sue your employer for their negligence. So if you have a coworker or a boss who does something negligent and hurts you, for example, you got a coworker who's driving a forklift and you're stocking a shelf and the forklift hits you, that really doesn't matter under Alabama law.
Doesn't get you any more than if you had the same injury.
So
walking and tripping over your own shoes.
In workers' comp, at least how you get hurt by a coworker or a boss doesn't really matter. Now, if the person who was on the forklift hit you was an independent contractor for some other company, well, hold on. That's a different story. That's called a third-party case, like you were talking about earlier. But the good thing and the bad thing about workers' comp is fault doesn't matter. It can be your own fault, doesn't matter. It can be a coworker's fault, doesn't matter, usually.
Wow, thank you so much. Well, when the Siniard Law Show returns, we'll get to more of your legal questions and we'll tell you how you can sign up for the Siniard Law Firm's free monthly newsletter.
Harrison Brothers brings together the best of North Alabama. Our curated selection of local art, fine crafts, and gourmet food are great gifts for everyone on your shopping list. We carry books by local authors, and our toys pique a child's imagination. At Harrison Brothers, your purchases support artists and artisans right here in the Tennessee Valley. Located on Huntsville's Courthouse Square since 1897, Harrison Brothers is more than a store. It's a tradition.
North Alabama's best attraction is not its mountains, or its rivers, or even its rockets. It's our people, honest, hardworking people who make us proud to do what we do. When people in our communities are injured in an accident,
we help them find insurance companies based in big cities far from here.
we are honored to help people get the compensation they deserve.
Siniard Law, nationally recognized, locally trusted.
Welcome back to the Siniard Law Show. If you would like to sign up for Siniard Law's newsletter, which provides free monthly legal tips, scan the QR code or be sure to sign up at siniardlaw.com. Now let's get back to you, our viewers, and your questions. Here is one from Steve. He says, I hurt my shoulder on the job and had to have surgery. The doctor has given me permanent restriction and says I can't go back to work. What should I do?
Well, if the doctor says he can't go back from work, then that affects the value of his workers' compensation case, because now he's lost his ability to earn at that level. What we see more often is the doctor says you're released to work, but the employer will not take you back because of your restrictions. So in those situations, if we could prove that failure to return that employee is retaliation for filing or pursuing a workers' compensation case, there's a second case, because you can't do that under Alabama law. You can't say, you filed a comp case, even though you had a perfect right to do it, or you got a lawyer who's a comp lawyer, we don't want you back here. You've got a second case for that. So in those situations, we handle retaliatory discharge cases, and some of those get pretty fiery. In regard to the value of his case with a devastating shoulder injury, because he's not been taken back and not making the same wage as he was before,
Even though the doctor said it.
Right.
Right.
Then he has a case that's much more valuable because it impairs his ability to earn what he was earning before.
Okay.
Mm-hmm. Yeah, I mean, in workers' compensation, what you're entitled to in regards to settlement value greatly depends on whether you can go back to work making the same amount of money. And that's true in what's called a non-scheduled injury. Mm-hmm. So Alabama's a little crazy. Workers' comp separates body parts amongst those that are on the schedule and those that are off the schedule. And schedules, it's literally a list of body parts that's in the Alabama Workers' Compensation Act.
It's like Far Side.
And it kind of tells you, and it's a little bit more complicated than this, but it kind of tells you what your case is worth. There's some multiplication involved and there's a few factors, but it's fairly straightforward. And scheduled injuries are fingers, hands, arms, legs,
eyes,
feet, toes and eye.
Fingers.
But the shoulder is?
Shoulder's off the schedule. So if it's an injury off the schedule, and that can be head injury, brain injury, neck injury, shoulders,
ruptured disc,
abdominal injuries, lower back, hips, all that stuff's off the schedule. And so the formula gets grayer, so to speak. And
better for the injured party, really.
Oh, absolutely. If your injury's off the schedule, and the way I tell people to think about that is it's mostly confined to your torso and head. If your injury's in that area and you can't go back to work making the same amount of money, then you have an argument that you are permanently and totally disabled under Alabama's workers' comp laws. And the disability, being totally disabled under workers' comp, is not always what you think of when you think of disability. Most people think if you're disabled, you can't do anything. But if you can't go back to work making the same amount of money with an off-the-schedule injury, we like to hire what's called a vocational expert, and we have you assessed by somebody who has this fancy degree and a lot of experience in determining how an injury has vocationally affected somebody, how that's affected their ability to earn a living. And that gives the ability to a judge to say, I think this person's permanently and totally disabled. And if a judge agrees with that, you can get a decent monetary recovery.
Decent means hundreds of thousands.
Yeah, there's no such thing as $1 million workers' comp case in Alabama. Mm-hmm. I mean, it's not always fair. You know, I've had a client, I resolved a workers' comp case for $340,000, and it was the proudest moment I've ever had handling a workers' comp case. That person had severe and life-altering injuries.
And $340,000.
No. And we were able to help him get on Social Security disability and, kind of plan for his future. But he was in his early 40s and has a lot of life left. But workers' comp is frustrating in Alabama because we have the worst workers' comp laws of any state in the union. And we haven't adjusted our rates or our formulas since the Reagan administration, back when you could buy something with $1.
Yeah, there's been no raise for people that are partially disabled.
Yeah.
And you guys have said before that not that many lawyers take workers'
I mean,
comp
we do it
cases.
because, I promised my dad, when I got out of law school, because he worked in a factory, that I would handle these type cases. And that's a promise I've kept. Mm-hmm. But, lawyers shooting for the moon, and all these billboard lawyers and ones that run 100 commercials, they don't touch workers' comp.
It's not lucrative for them.
It's not lucrative. The fee is only 15%. And, we still take people with broken fingers, and, much to the chagrin of the other lawyers in my office, we are committed to helping injured working people, if it's a dime or if it's, $200,000. And, that's a calling card that I'm proud of.
Good, you should be. Let's get to this next email. It's from Jimmy. He says, I am a concrete truck driver who got hit head on by a commercial moving van. I'm out of work now on workers' comp. Will I need a lawyer? What would y'all say to Jimmy?
Yeah, that's a situation where you probably do need a lawyer. And let me just give this disclaimer. We try to be the firm that doesn't give a sales pitch to anybody who calls our office. If I think you can handle a claim on your own, I'll just kind of give you, a 10-minute lesson over the phone or in person about what you need to do. In a situation like Jimmy's, though, I almost guarantee you he really needs a lawyer. He might can figure it out on his own, but let me explain why he does need a lawyer. If you've been watching, this show tonight from the beginning, you probably now realize Jimmy has two cases. He was injured on the job, so he has a workers' comp claim, but he also has what's called the third-party claim against the van driver. And those kind of work in tandem. They're related to each other, and there's a lot of moving parts that can intertwine. And if you don't know how they intertwine, you can really screw up.
Badly.
And here's the biggest way they intertwine. Since he's getting medical treatment for an on-the-job injury, workers' comp is paying for his medical treatment. That's one of the benefits you get when you're injured on the job, is that you don't have to pay anything out of pocket for medical treatment. In this situation, workers' comp is gonna wanna get reimbursed if you get a settlement with the moving van company's insurance company, and they have a legal right to that. So let's just, and I don't know how bad Jimmy's injuries are or how much medical treatment's needed, but let's say workers' comp insurance pays $30,000. Let's say he has to go to the ER, he has to get injections, he needs physical therapy, he needs his knee scoped, whatever it may be. And let's say he makes a claim with the moving van company's insurance. Let's say he gets a settlement of $100,000. Well, he may think, yay, great, I'm excited about this. The problem is workers' comp is going to get a big chunk of his $100,000 settlement, not only for the $30,000 in medical that workers' comp paid, but if they paid him those 2/3 of your average weekly wage, they get to tack that on top. So when you got two claims, you need a lawyer. That's just one of the ways they intertwine. There's other ways that you can mess up, even if you're really intelligent, because a lot of it's just not common sense.
People call, and there are cases where we instruct people how to navigate it themselves. Somebody's rear-ended, they got one trip to the ER, they're fine, they haven't missed but a day of work. And we say, here's what you do, get your medical bills, document your lost wage, and here's the range of what you should accept. Don't pay an attorney, don't pay us for that. We do that. There's no charge for initial consultation in our office. But when it gets more complex than that, what I tell people is, when they say, can I do it by myself? I said, well, with a sharp enough knife and a good mirror, you can take out your own tonsils. But doctors don't recommend that. And so that's how I feel with your case. So we're not out to scalp somebody, but why would it hurt to call and say, do I have a case, do I not? If so, what's the fee? When do I pay the fee? People just are terrified of calling lawyers. We want to make it where there's no fear involved and sort of give you a horseback opinion as to, one, have you got a case, and two, what it's worth, and three, can you handle it without us or some other firm?
Yeah, and if we can't help you for whatever reason, we can always point you in the right direction. You know, we primarily handle personal injury. That's anything where somebody's been hurt or killed due to, you know, the wrongful conduct of somebody else or being hurt on the job.
But like you said, you can go in and just have a consultation, just talk about it.
So, you know, this is how it works, at least at our office. If you've been hurt and you're calling in, you will speak with our new client coordinator, Teresa or Tanya, and they'll get the details of the situation. And if it's a case we handle, then we will schedule an appointment to talk with you, either come to your house if you want us to, meet at our office in downtown Huntsville. We can do it via Zoom now. We learned how to do that after COVID, or I did.
Easy.
Yeah, just messing with you. And we meet with you. It's usually 30 minutes to an hour. It can be shorter. It can be longer. We try to answer all your questions. And if you want to hire us, we explain what the process looks like, give you some resources on our website, to better familiarize yourself with the process. And we have you sign documentation that officially allows us to represent you. And that includes fee agreement. We work on a contingency fee basis, which means we're paid a percentage if we win the case. You don't pay us out of pocket ever. And we also have to have some other forms signed that allow us to get your medical records and medical bills. HIPAA, we can't do any of that without
Lost
your
wage
permission.
information.
Yeah, and then we hit the ground running. And the process, it can take a while. A lot of times people think they get hurt in an accident, they're going to get a check, the next week. That's not how it works. And we tell people that up front. We're not magicians, but we are lawyers and we know what we're doing. But we think we do a pretty good job. And, if you've been hurt in any way or have a loved one that's been hurt, we're here to help.
All right, sounds great. And just explaining that step by step, what happens, I think would be really helpful to people to not be intimidated by calling a lawyer.
Right.
So we appreciate that very much. Thank you, Tommy. And
Thank you,
Aaron.
Aaron.
We appreciate it. And we appreciate all this information they've given us tonight about workers' comp. And we look forward to hearing from you, our viewers, with your questions about workers' comp or any other legal topic. You can email us at questions@siniardlaw.com or call our voicemail line at 844-7000-LAW. Join us next Sunday night after the late news. Have a good night.
The preceding was a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys.